Hello everyone, my name is Kanishk and you are watching Legal Reasoning Basic to Advanced. In this lecture or in this particular video of the course, we'll be discussing the last two paragraphs of the paper of 2021. Then we'll summarize how the paper was different from the paper of 2020. We'll see how the passages have changed. We'll see what are the major differences, what was the paper expecting out of us, and what are we supposed to do. The belief that we have instilled up until now is that we do not require prior knowledge of law. Rather, we require someone who is comfortable reading law, who is comfortable reading articles related to law. So, without wasting any more time, let's start solving the passages. Marriage is necessarily the basis of social organization and the foundation of important legal rights and obligations. So from this first line, we are certain about the fact that the entire passage is going to talk about marriage and the ordeals related to marriage and the law related to marriage. The importance and imperative character of the institution of marriage needs no comment. In Hindu law, marriage is treated as samaskara or a sacrament. The Hindu Marriage Act 1955 introduced monogamy as a law of marriage among Hindus by the virtue of section 5 clause 1, which is essentially voluntary union of life for life of one man with one woman to the exclusion of all others. So this is the law that we can use for answering the questions. Okay, let's move ahead. It enacts neither party must have a spouse living at the time of marriage. The expression spouse here used means a lawfully married husband or wife. So this again is an extension of the law that is provided to us. First of all, what is marriage? It is a union of one man with one woman to the exclusion of all others. It enacts neither party must have a spouse living at the time of marriage. The expression spouse here means a lawfully married husband or wife. Fair? So now he has explained, the author has explained the meaning of what is a spouse. So a spouse can be a spouse cannot be merely someone you call to be your wife or you call to be your husband, but rather a spouse is someone who you are lawfully married to. You are their lawful husband or their lawful wife. Fair. Before a valid marriage can be solemnized, both parties to such marriage must be either single or divorced or a widow or a widower, and only then they are competent to enter into a valid marriage. Fair. So before a valid marriage can be solemnized, in terms solemnized means completed through rites and rituals, both parties to such marriage must be either single or divorced or a widow or a widower. So this is a basic requisite required for somebody to marry. They must be single, divorced, a widow or a widower, and only then they are competent to enter into a valid marriage. If at the time of the performance of marriage rites and ceremonies, one of the other parties had a spouse living and the earlier marriage had not already been set aside, the later marriage is no marriage at all. So let's consider that A and B are married to each other. Then we have a person C. Now A goes on and marries C without divorcing B, or in a condition that B is alive and they have not set aside the marriage. If B is dead and A is a widow, or if B and A have settled on a divorce, then and only then can A marry C. If without any of these conditions coming into play, one being A marrying C without giving a divorce to B, or A marrying C with B being alive and not B being alive and being still validly married to A cannot marry C. Fair. Let's move ahead. Supreme Court in Bhaura Shankar Lokhande versus State of Maharashtra held prima facie the expression whoever marries in section 494 of the Indian Penal Code must mean whoever marries validly or whoever marries and whose marriage is a valid one. Fair. If marriage is not valid according to the law applicable to the parties, no question arises of it being void by the reason of it taking place during the life of husband or wife or the husband or wife of the person married. One of the conditions of a valid marriage under the Hindu Marriage Act 1955 is that it must be solemnized. Now, what does solemnized mean? Solemnized, as I have earlier told you, means completion of a marriage through proper rites or rituals that are associated with a particular religion of the people being married. For our cause, we can take the Hindu religion, all the functions that are involved, all the rituals that are involved, until and unless they are performed, until and unless some people have witnessed it, we cannot call a marriage to be solemnized. Basically, you just can't go to a person and state that he or she is my wife or husband, and without uh, properly solemnizing the marriage through rituals, they cannot be called your husband or wife. Further, Section 13, Clause 2 of the Act provides for grounds of divorce to wife and states. Fair. A wife may also present a petition for the dissolution of her marriage by a decree of divorce on grounds that in case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement was alive at the time of the solemnization of the marriage of the petitioner, provided that in either case other wife alive at the time of the presentation. Fair. So basically 13 clause 2 states that a wife may also present a petition. So they are saying that a wife has the power to present a petition or move to the courts for divorce. Fair. On the ground that in case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or any other wife of the husband married before such commencement. So the husband had married two individuals, that could be a reason for a wife to move a petition of dissolution of marriage. So now let's look at the questions. Mr. A, a 40-year-old Hindu male, was married to Miss B, a 36-year-old Hindu female. Mr. A fell in love with his colleague Miss C, a 22-year-old female Christian. On April 8, 2020, Mr. A declared Miss C as his wife in front of all of his colleagues, family members and relatives. Based on the given fact, decide the liability of Mr. A as per the Hindu law. Fair. So, A was married to B, both were Hindus coming from the same religion, and then one day Mr. A fell in love with his colleague Miss C, and in front of all the individuals he stated that now Mr. A and Mr. C are a couple and they are wedded as man and women. Can this be called a valid marriage? As we have discussed in the paragraph earlier, that for a marriage to be called a valid marriage, there should have been no marriage of the parties involved. If there was a marriage, either they must be a widow or a widower, or they must be divorced of their last spouse. In this case, they are not divorced of the last spouse, neither solemnization has occurred. Means no ritual or rite was followed. So let's see what happens. A is not liable for the offense as Miss C is Christian. No, it's a vague option. Mr. A is liable for the offense of bigamy as mere declaration also amounts to solemnization. No, it does not amount to solemnization. Solemnization is completely restricted to the idea of performance of rituals of any of the parties involved in such an act. Mr. A is not liable for the offense of bigamy as he has not solemnized his marriage with Miss C. Fair, good option. And Mr. A is liable for the offense as there was no intention to marry. No, we aren't talking about intention, so we'll choose option C as the most appropriate answer and we'll move. Which of the following statements correctly express the interpretation of the word solemnize under the Hindu law? Solemnization means celebrating the marriage with proper customary rites and ceremonies of either party to marry. ठीक है, fair, valid. Solemnization includes and means promising each other of lifetime happiness. No, it's vague. Solemnization is not necessary in modern marriages when registration of marriage is complete. Are we informed of any such law? No, we haven't been informed of any such idea. Okay. Solemnization is mere formal practice and not a mandate. No, as we have been told in the paragraph, in the later part of the paragraph, that solemnization is important for marriages to conclude. So we cannot state that it is an unimportant ritual. So we'll choose option A as the most appropriate option and we'll move ahead. Which of the following is not correct regarding the law of monogamy among Hindus? Monogamy is a union of man and woman which provides the relation a social and legal recognition. Fair. Monogamy as law was abolished after 55. Have we been provided any dates? Have we been told about introduced 1955 introduced monogamy? Fair. So we'll see and check option B as the option that's not correct in relation to the Hindu Marriage Act and monogamy in relation to Hindus, and we'll move ahead. On the basis of section 13 of the Hindu Marriage Act 1955, which of the statements does not relate to the remedy? Remedy, we were talking about remedy in terms of women getting the remedy of moving to courts to file for dissolution of marriages. The object of the section was to provide an opportunity to the wife in form of remedy of divorce. Fair, understandable. The introduction of this ground of divorce is unnecessary as it disturbs the marital institution. No, how can a remedy disturb a marital institution? Rather, it saves the rights of the individuals that are involved in such a bond. So option B being a vague option. A remedy is only available under this section if the husband has other wife living. Fair. The living status of either spouse is immaterial to claim the remedy. Fair. Let's move ahead. Though option D also is somewhat wrong, but there are questions that get deleted and that are on some grounds here and there. Because the living status of the either spouse is material and will always remain material. Fair. So let's move ahead. 34. Mr. P, a 20-year-old male Hindu, was legally married to Miss Q, a 26-year-old female Hindu. P converts to Islam to marry Miss N, a 30-year-old Sunni female Muslim. Consider the statement and decide whether Miss Q has the remedy to file a complaint for the offense of bigamy against Mr. P. So there are two individuals that have married each other, are from the same religion, that is Hinduism. Then one of the individual converts to some other religion, that is Islam, and marries a different woman, which is Miss N. But any marriage is not a legal marriage according to the Hindu law until and unless the individuals involved in it are either divorced or are either widowers or are not married to anyone. So, can Mr. P file an offense of bigamy? Can Mr. P be filed for offense again? Bigamy? No, Miss Q cannot file as it defeats the very purpose of marriage with Mr. P. No. Miss Q can file a complaint to the subject of approval by Miss N. No. Miss Q cannot file a complaint as Mr. P converted to other religion on the offense of bigamy will not. No. Yes, Mr. Q has the remedy of filing for the offense of bigamy. So, in this case, what is bigamy? That is, as that was defined, bigamy or marriage. Marriage is a union between two individuals and at the exclusion of all the others. Fair? So, him marrying, converting to other religion, marrying someone else is basically raising the question of validity on his first, what we would say, marriage. And him being a male has married two females. This is a case of bigamy. Fair? But can that marriage be considered valid? No, it will not be considered valid. But then again, can he be booked for bigamy? Yes, he can be. Miss N, is her approval mandatory? No, we will not say that her approval is mandatory. No, we'll avoid. Miss Q has the remedy of filing a complaint of bigamy. This is the right option. And with this, we will finish this particular paragraph. Just a second. Sorry for the interference and the disturbance caused. So, this is the second passage that we'll be discussing today. The Indian Penal Code 1860 does not define consent in positive terms. But what cannot be regarded as consent under the code is explained by section 90. Section 80 reads as follows. 90 reads as follows. Consent known to be given under fear or misconception. So, they are here talking about a section of the IPC. A consent is not such a consent as is intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing that knows or has reason to believe that the consent was given in consequence of such fear or misconception. We'll read it once again for clarity. A consent is not such a consent as is intended by any section of this code if the consent is given by a person, first of all, under fear of injury or under misconception of fact, and if the person doing that knows or has reason to believe that the consent was given in consequence of such fear or misconception. So, in the entire code, consent will not amount to consent that was given under misconception of facts, where facts were unknown or misconceived, and also under fear of injury, where somebody, let's imagine that there is a contract that is to be signed between parties A and B. Now, party A says to party B that if you do not sign the contract, I shall kill you. So this threatening of party A to party B will amount to fear of injury, and under this fear of injury, if party B agrees and provides consent, it will not be considered a valid consent. Let's move ahead. Consent given firstly under the fear of injury and secondly under a misconception of fact is not consent at all. Fair? This is what we just discussed. That is what is enjoyed by the first part of section 90. These two grounds specified in section 90 are analogous to coercion and mistake of fact. These two grounds specified in section 90 are analogous to coercion and mistake of fact, which are familiar grounds that can vitiate a transaction under the jurisprudence of our country as well as other countries. Fair? So these two things are analogous to the fear of injury and misconception of facts as mentioned above. The factors set out in the first part of section 90 are from the point of view of the victim. The second part of section 90 enacts the corresponding provision from the point of view of accused. It envisages that the accused too has knowledge or has reason to believe that the consent was given by the victim in consequence of fear of injury, misconception of fact. Thus, the second part lays emphasis on knowledge or reasonable belief of the person who obtains tainted consent. This might be important while we solve our questions. The requirement of both the parts should be cumulatively satisfied. In other words, the court has to see whether the person giving the consent had given it under fear of injury or misconception of fact. And the court should also be satisfied that the person doing the act, the alleged offender, is conscious of the fact or should have reason to think that but for the fear of misconception, the consent would not have been given. This is the scheme of section 90, which is couched in negative terminology. Section 90 cannot, however, be construed as an exhaustive definition of consent for the purpose of Indian Penal Code. The normal connotation and concept of consent is not intended to be excluded. The normal connotation or the consent or the concept of consent is not intended to be excluded. Various decisions of High Court and Supreme Court have not merely gone by the language of section 90 but travelled a wider field guiding the etymology of the word consent. Fair. Now we have understood what consent is and what is not consent. The consent in this particular paragraph has been defined by defining what is not consent, because what is consent might be, or might have different interpretations, might have several interpretations, but the exhaustive part or the part that has limitations is the part that so yeah, they exhaustively define the part of what is not consent, because that would then allow us to take away all the ideas or take away all the scenarios that are not consent and would allow us to choose what is the right consent, what is the valid consent. Fair? Now let's move to the questions. A man promises B, a woman, that he will marry her if she has sexual intercourse with him. B agrees, but after having sexual intercourse, A flees and never contacts B. In the given situation, which statement is true? Consent for sexual intercourse was given under misconception of fact. Consent for sexual intercourse was given under fear of injury. Consent for sexual intercourse was given under undue influence, or consent for sexual intercourse was given without any misconception or fear of injury. So, in this scenario, we have two things: a fear of injury and a misconception of fact. Misconception of fact being a place or an idea where you conceived fact to be something, and rather in reality it was something else. Fair. So in this particular question, neither she had fear of injury, but we can say that she had misconception of fact, because the reality was the man was not to marry her. So we'll choose option A and we'll move ahead. According to the given passage, a person is said to consent to doing an act if a person agrees to do an act without misconception of fact or fear of injury. Fair. The person to whom the agreement is signified has no reason to believe that agreement is being given under misconception or fear of injury. A person agrees to do an act without misconception of fact or injury, and the person to whom the agreement is signified has no reason to believe that the agreement is being given under misconception of fact or fear of injury. This particular point justifies the condition that was given in the earlier part of the paragraph, and the later part of the paragraph is stated that not only the person that is being that is that is being called the victim of such a situation, rather a person who also was the offender here, who was also the perpetrator here, needs to know or needs to be aware of the fact that if such a consent is coming from misconception or if it is coming freely. This satisfies both the scenarios. So we will correct option C, choose option C and move ahead. According to your understanding of the given passage, why is negative terminology used to explain the meaning of consent? To emphasize on the factors that vitiate consent? Fair. To emphasize on the point of view of the victim or the person who gives consent? No, because then it emphasizes on both the individuals involved, the one who gained the consent and the one who gave the consent. To emphasize on the point of view of the person who receives? No. To emphasize on the non-exhaustive scope of the definition of consent. This is a better choice when compared to A. So we'll choose this option and we'll move ahead. X, a man promises Y, a woman, that he will marry her if she has sexual intercourse with him. Y agrees and then they have sexual intercourse. Thereafter, X assures Y that they will get married. But X's family is opposed to the marriage even after X's attempt to convince them. Therefore, X refuses to marry. Now, in this particular situation, X was of the opinion that he would marry her. There was no negative element on his part. He wasn't of the opinion that he will only use the other person by for physical benefits. Rather, he was of the opinion that they will marry each other. Also, Y was of the opinion that they will marry each other. So the consent that was thus obtained was a consent of free and fair nature. But later on, the family of X opposed the entire idea of X getting married to Y. So let's see what's the answer. Consent for sexual intercourse was received knowing that the consent is given under misconception of fact. No. Consent for sexual intercourse was given without any misconception of fact or fear of injury. I will consider it to be a strong option. Consent for a sexual intercourse was received knowing that the consent is given under fear of injury. No, there was no fear of injury involved. consent for sexual intercourse was given under misconception of fact and received misconception of fact? No. Option B is the only correct option. 39. According to the given passage, which of the following is not true? Misconception of fact vitiates consent. Fair. Fear of injury vitiates consent. Fair. Misconception of fact obviates the necessity of consent. No. Fear of injury is analogous to coercion as stated in the paragraph. So option C is the odd one out already by considering the other three the right one. And I guess this is the last question of this particular exercise. The questions in this particular paper were a bit different from the one we solved earlier. In this, the language was a bit more technical when compared to the paper that we have solved earlier. Not only the language, the law was a bit hidden and you had to look out for it rather than given to you in forms of principles and tests that was done in the previous paper. Though I would still state that without knowledge of law, without the idea of what the sections are or what anything is, you can basically crack this paper. Not only this, but also the fact that it is just somebody who reads law, who's interested in the legal arena, can solve these questions if you read them properly. This was Kanesh. You are watching King's Academy, and this is Legal Reasoning Basic to Advanced. Thank you for watching, and I'll see you in the next one.